Hello, everybody. This is episode 21, Utopia. This is known and scripted. This episode is Quarter Life Crisis. Judge Cannon denies Department of Justice's motion for partial stay. I'm going to try again to keep this as cut and dry as possible. Uh, I've come to you before and explained in great detail why what Judge Cannon is doing is unprecedented. I made two videos about that after the DOJ filed their initial reply, and then after the DOJ filed their motion for partial stay. Um, Now, I want to tell you as what I found to be interesting in Judge Cannon's order. So I'm going to read parts of the order for you. Here we go. In many respects, the government's position thus presupposes the content designation and associated interests and material under its control. Yet, as the parties' competing filings reveal, there are disputes as to the proper designation of the seized materials, the legal implications flowing from those designations, and the intersecting bodies of law permeating those designations. The disputes that the judge is talking about here are disputes that are resolved when a case is brought to court. The dispute has not been brought to court yet. The Department of Justice has not brought suit yet. This is um, an aberration in the sense that Donald has taken one issue from uh, an ongoing criminal investigation and brought it over to a civilian court, a civil court, and Judge Cannon has exercised equitable jurisdiction to look at this case. Now, the disputes about whether the materials are classified or not, it's what the judge is saying here is that it's me taking the DOJ's word for it or me taking the Donald Trump's word for it. And she's saying, I have no reason to take either. So that's why I'm going to assign a special master. However, this neutrality, this whole equitable jurisdictional thing happens during and after a trial, after there has been fact finding, after there has been evidentiary disclosures between the defendant and the plaintiff, um, or and none of that has happened yet. So these disputes that she's talking about is essentially Donald Trump, Donald Trump's arguments that are vague and overbroad versus the Department of Justice's assertions that are as specific as they can be without compromising national security. And the judge is not convinced by the amount of information that the Department of Justice has provided to uh, conclusively state that these documents really do warrant the amount of um, security and provisional access as possible. The judge goes on and says the September 5th order does not restrict the government from conducting investigations or bringing charges based on anything other than the actual content of the seized materials, from questioning witnesses and obtaining other information about the movement and storage of seized materials, including documents marked as classified, without discussion of their contents, from briefing congressional leaders with intelligence oversight responsibilities on the seized materials, from reviewing the seized materials to conduct the security assessments, or from involving the FBI in the foregoing actions. Moreover, as indicated in the September 5th order, the temporary restraint does not prevent the government from continuing to review and use the materials seized for purposes of intelligence classification and national security assessments. Hence, as plaintiff acknowledges, to the extent that such intelligence review becomes truly and necessarily inseparable from criminal and investigative efforts concerning the content of the seized materials, the September 5th order does not enjoin the government from proceeding with its security assessments. This is the reason why in the description of this video I said that this is tricky, right? On its face, the denial of the special master partial stay can come off as the judge enjoining the Department of Justice completely and not clarifying any of the questions that the DOJ had presented to the judge in their last filing and the filing before that. Here, the court says that you can go ahead and bring charges on anything except for the contents of the seized materials. So while DOJ scalpeled out 100 classified documents out of 11,000, which they're saying should just be shielded from the special master review altogether. And the judge is saying that no, only what her order is saying essentially is that I'm going to allow the special master to look at everything, and the DOJ can continue to do all these other things without discussion of the contents in the seized materials, which I would venture to guess, and as the overseeing official pointed out, that it would be exceedingly difficult. And here you see this callous approach of Aileen Cannon, where she reads the DOJ and the FBI's plea to the court as saying that it's going to be exceedingly difficult for us to conduct our security assessment without also doing the attendant investigation. Here, the judge is saying that you can do all the investigation and everything that you want, and the FBI can investigate to the extent of security assessments, but you can't bring charges, or you can't review. You can't interview witnesses and subpoena people on discussion of what's in the seized materials. In terms of moving the seized materials where it was and all that, you can do that. You can also apprise congressional leaders with oversight authority of what's going on. But I won't stop my special master order. And you saying that those classified documents are too classified for the special master to look at, I don't agree with that. Okay. Now here's where she gets over smart. Mindful of the traditional reluctance to intrude upon the authority of the executive in military and national security affairs, the court nonetheless cannot abide and cannot abdicate its control over questions of privilege, and does not find the government's arguments sufficiently convincing as presented. So because the judge says, I don't believe that the DOJ's assertion that these documents really are this classified, because there is dispute on that matter, because that's what Donald is saying on the other side, I'm not going to defer to the executive branch on matters that have traditionally been deferred to the executive branch, and say that there's no privilege, that a former POTUS does not have any privilege over these documents, because I don't believe that they're sufficiently classified, because DOJ hasn't proven that sufficiently, which the DOJ can't do at this point, by the way, because the investigation is ongoing and the material case, has not been brought to court for adjudication, as I mentioned earlier. There has been no actual suggestion by government of any identifiable emergency or imminent disclosure of classified information arising from plaintiffs' alleged unlawful retention of the seized property. Instead, and unfortunately, the unwarranted disclosure that float in the background have been leaked to the media after the underlying seizure. So here, Aileen Cannon is attacking the media. I think a Washington Post article that talked about what was in the documents. And that's neither here nor there, because in the DOJ's filings to Judge Cannon's court, it has made it abundantly clear, to the point where non-lawyers, somebody like me who has never worked at the Department of Justice, who only knows how to, read legal stuff and is just a wonk who is obsessed, can read it and understand that there are matters here that we don't need to get any more specific about at this point, because we are not even at the pre-trial stages. DOJ hasn't even made a decision on whether they will issue an indictment. They've simply they've just seized the property that Donald was never supposed to have. And here Judge Cannon says, according to you. I don't believe you. How absurd that is. I mean, on so many levels. And I expect that we're going to see a 40-page appeal on every single issue. And I feel that this is where the DOJ will bring out all the jurisdictional arguments, which they did raise, by the way, but didn't go into in their filings with Judge Cannon, because they gave the court so many alternative arguments that, going into the obvious jurisdictional weakness of Judge Cannon's keeping the case, just wasn't one of those many alternates that they described explicitly, but they did bring it up. Now, the Kohler Declaration, now it's this the DOJ individual who's overseeing this investigation. The Kohler Declaration, for example, states that it would be exceedingly difficult to bifurcate the personnel involved in the described process, and then it proceeds to posit hypothetical conflicts that could rise if security assessments require criminal investigative efforts. The government submissions read collectively do not firmly maintain that the described processes are inextricably intertwined, and instead rely heavily on hypothetical scenarios and generalized explanation that do not establish irreparable injury. Third, as noted above, to the extent that security assessments truly are, in fact, inextricable from the criminal investigative use of the seized materials, the court makes clear that the September 5th order does not enjoin the government from taking actions necessary to the security assessments. And finally, in light of the government's security assessments, okay, I'm going to stop there. I'm going to stop there because I'm going to go and read you footnote 5 that is talking about what the judge means by security assessment, okay? Needless to say, the court is confident that the government will faithfully adhere to a proper understanding of the term inextricable, and where possible, minimize the use and disclosure of seized materials in accordance with the court's orders, because the court is not privy to the specific details of the government's investigative efforts and national security review, the court expects the government in general is best suited to assess whether contemplated actions are consistent with the standard described herein. So Judge Cannon, after saying no, I'm not going to agree with your assessment that this is classified information that not even the special master should see, these 100 documents, I leave it to you to make the security assessment of to what extent you can disclose these materials. It's the circuitous absurdity that is insulting to the federal judiciary, and it makes it difficult for the 11th Circuit to say outright that it wasn't narrowly tailored to this particular very specific idea of a special master for equitable reasons. Again, going back, the issue of equity and remedy comes when a case has been brought and fact finding has happened and it has been adjudicated, and then you realize, okay, we know all these things, all these facts, and now we can assess what the harm has been and therefore what the remedy or what the equitable charge should be. To have this pre-judicial civil case pop out of an ongoing DOJ criminal investigation on the basis of equitable jurisdiction, while saying that there isn't enough evidence because the DOJ is saying we can't show you the evidence because we assert that it's classified and it's part of the executive branch's responsibilities, and the judiciary does not have any authority to look at it. Neither does a special master, who is neither part of the judiciary nor part of the executive branch nor part of Congress. And Congress is not even in this. And it might get into this when Judge Cannon is going to be impeached, because that's where this is going. So we're going to go to then finally. And finally, in light of the government's stated concerns, the court will direct the special master to prioritize review of the approximately 100 documents marked as classified and papers physically attached thereto, and thereafter consider prompt adjustments to the court's orders as necessary. Whoever wrote this is still stuck on thereby adhere to and hereafter. You can't write in simple English, giving out this idea that, I'm going to make the circuitous argument, so I am, and put in these words of legalese and jargon, so to make it seem that I'm making a sound argument because it's such a narrowly tailored thing that I'm saying, which is entirely arbitrary because she doesn't know whether it's narrowly or widely, because she herself says that she doesn't know what's going on in the investigation because she's not privy to it. Here, the government also presents an argument in passing that making the full scope of the seized materials available to the special master would itself create irreparable harm. Insofar as the government argues the disclosure to a special master of documents marked as classified necessarily creates an irreparable injury because the special master process in this case is unnecessary, the court disagrees for the reasons previously stated. Separately, to the extent that the government appears to suggest that it would suffer independent and irreparable harm from review of documents by the court's designee with appropriate clearances and controlled access, that argument is meritless. It's not meritless because the materials are definitionally classified and belong to the executive branch. They don't belong to the judiciary. The issue of reviewing those documents to see what's privileged or not has been done by the executive branch that owns this material. To bring in a special master would compromise the national security of the United States. Per the executive branch, and as Judge Cannon in her footnote acknowledges that it is the executive branch's domain. But then again, says that the special master coming in wouldn't change anything. Essentially, it's an independent counsel, so to speak. And evidently, Judge Deary is a reliable person. Whatever the case is, I want you to know that the overarching theme of this whole special master thing is delay and obstruction. And delay and obstruction to delay Donald's prosecution. What it is, however, more importantly, delaying and obstructing is an investigation into national security interests that are at stake, given the nature of the documents that were recovered. And that goes as far as to say that it is possible that there are people out there who provide our government with critical intelligence, and they will be exposed or are exposed from the information that has already been compromised and continues to be compromised. How that compelling interest of the government is not more than the harm to Donald's reputation, because Donald is in a unique place and this is a case of first impression, is a matter of debate for trial. And that happens when the trial and the pretrial processes, as I've said many times over, happens. That hasn't even happened yet. Lastly, the court agrees with the government that the public is best served by even-handed adherence to established principles of civil and criminal procedure, regardless of the personal identity of the parties involved. It is also true, of course, that even-handed procedure does not demand unquestioning trust in the determination of the Department of Justice. Oh, well, fine. Okay, that's like, okay, fuck you, DOJ. That's fine. You can do that. Except that determination and even-handedness happens during the civil and criminal procedure, not during the investigative process. Based on the nature of this action, the principles of equity require the government to consider the specific context at issue, and that consideration is inherently impacted by the position formerly held by the plaintiff. Well, I talked about the whole thing about first impression and it being a former POTUS. He's a private citizen right now who stole classified materials from the government that he had to return. Mind you, if these materials rightfully belong to Donald Trump, then somebody would have been standing there telling the FBI, no, we're not going to let you in. We're going to take this to court. You're not going to be able to take these materials. They don't belong to you. But they can't do that simply because, not only because these documents don't belong to them, but because they've acknowledged a lot of them don't belong to them because they've given them back in May and in June. And the DOJ points that out, that at no point did in May and June did Donald's lawyers bring up executive privilege or any sort of privilege. The court endeavors to continue, the court thus continues to endeavor to serve the public trust, the principles of civil and criminal procedure, and the principles of equity. And the court remains firmly of the view that appointment of a special master to conduct the review of seized materials, accompanied by a temporary injunction to avoid unwarranted use and disclosure of potentially privileged and or personal materials, is fully consonant with the foregoing principles and with the need to ensure at least the appearance of fairness and integrity under unprecedented circumstances. The unprecedented circumstance here is the fact that a federal executive stole government classified documents, kept them for over 20 months, acknowledged to taking classified documents, returned parts of them, then returned some others, attesting to not having any more, then refusing to cooperate after being found out that they had more, and then a warrant being executed on their premises. And 2 weeks after that, they assert their privileges and take it to a specific judge. And that judge asserts an equitable jurisdiction because this is an unprecedented circumstances. Now, the unprecedented circumstance is the fact that this executive took these materials, and the fact that he had to return them shows that it never belonged to them. The burden of whether these documents belong to Donald had to show them. And Donald didn't show that in the filings with the special master. It just said that, no, we need a third party to come in and look at it. Why? If you claim that these things are privileged, that you have the right to have them, then you go to court specifically saying, no, give them back. Why the special master? Give me back my documents. They're mine. And here are the reasons why. But he's not doing any of that. And the principle of equity here falls in favor of the government, because the government has been, through the National Archives, through the Department of Justice, has been working with Donald's lawyers for months and months and years now to get these documents, because they've figured out that they didn't have these documents as soon as the National Archives got whatever documents that they received after Donald left. It's not hard to do. Something is missing, you figure it out eventually. And then you go looking for it, and then you find it, and then you ask for it back. They give some of it back. They don't give some of it back. Then they give some more of it back, and they say, okay, we don't have any more. Then it's found out that they have more, and then they have to give it back. They don't want to give it back. And then they go to court saying that they are mine. I want somebody else to come and tell you that they're mine. No, I don't want them back right now. I want somebody else to tell everybody what is government. So he's not saying that I don't have classified documents. It's the most absurd, outlandish thing to happen in a judiciary. It's the most flagrant exercise of judicial overreach and malpractice that you can. And if she is thinking that this is conservative because she is chiseling out and allowing the government to do all this work except for the content of those seized documents, then she's jaded. And she thinks that she can hoodwink people into thinking that this the over-scalpeled approach is in any way equitable to any party. So, because of those considerations that she pointed out, because of this idea that, okay, no, I'll give the DOJ these things that they can do, because, the Agent Kohler didn't say that it was impossible, It said that it was exceedingly difficult. So, this is Judge Aileen Cannon saying, I'm making it difficult for you because of who Donald used to be, notwithstanding what he has done. Because even if he did what he did correctly when he was president, the moment he stopped being president, he no longer had right to those documents. So, I expect the DOJ will file their appeal today, if not, I expect that. Hey, Janet, thank you for shedding light. Thank you for being here. I appreciate you. I'm looking at the chat right now. The substantive portion is over. Now we just have to wait and see what the DOJ does, and their 40+ page appeal, I would expect. Thank you for listening. Thank you for being here, and hold fast. Oh, mind you, there are some. I just want to do an update really quickly. Mark Meadows is complying with DOJ grand jury into January 6th. It's a bad news for Donald Trump. The Stewart Rhodes seditious conspiracy trial begins on the 27th of this month. And I'll repeat what I said before. Stewart Rhodes is not the mastermind of the seditious conspiracy for which he's standing trial. That distinction goes to Donald Trump. And Donald Trump and people around him will see several felony indictments in due course. It's not a matter of if, it's a matter of when. Whatever political considerations and whatever opinions are floating around have to take into consideration the burden the Department of Justice has in upholding the rule of law and what it would mean if the Department of Justice said, yeah, the boots on the ground, as Glenn Kirshner puts it, that the boots on the ground will pay the price, but the suits of the conspiracy won't. That won't happen. John Eastman, the January 6th committee has asked for more of John Eastman's emails, and the committee is likely to get them. And I've said this before, no matter who else does or does not get indicted for seditious conspiracy, John Eastman will. He is the architect of Donald's fake elector scheme. He is the one who spun Donald out of control, along with Rudy Giuliani. And Mark Meadows was there to supporting services. Now, the last thing is that the next January 6th committee hearing will be on the 28th of September. I would expect to hear testimony of Pat Cipollone, of Mike Pence's former officials, of his administration, well, his officials, and I'd expect to hear more about the Secret Service text messages. We heard a walkie-talkie conversation that was haunting, that was released by the committee on Twitter, about how Donald's tweet had told his followers to stand with the Capitol officers, but notice how he didn't say anything about the members of Congress. That's haunting, and I suspect we're going to hear more of that. Okay, and if all of you who have watched my previous videos and have seen me forecast these things know what I'll say about we're still at the base camp, okay, of Mount Everest, that is Donald's crimes against our republic, and we can slowly start to see it. We're walking out of the base camp and we're going up now towards the summit, and we're slowly starting to get an idea of how expansive and big this conspiracy is, and Donald's treason plot is multifaceted. What he's done to compromise our national security, what he's done to overthrow our republic, the way our government is run is unprecedented. It is he is a national security threat. He's a clear and present danger to our democracy, and he's opening in plain view. I think that Merrick Garland is cognizant of this fact. I think that the DOJ is working as deliberatively and as expeditiously as it can. And while uh, you know roadblocks like Aileen Cannon's ruling can slow down the wheel of justice, it will not stop it. That's simply not going to happen. Donald has exhausted every um, way of stopping our government for investigating January 6th. He tried, he failed. And that is moving on smoothly. And that is the silver lining that we have to move forward. September is going to be another revelatory month, and it's going to be at the end of September. And I implore everybody to go to the January 6th YouTube page and watch the hearings, listen to the hearings, speed up the videos. And um, if you want an assessment of each of them, I have reviews of all of the hearings in the Utopia playlist of No One Unscripted. Okay. Thank you so much. Thank you, Janet. I will see you guys and ladies later.